The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Two cases will be heard this afternoon. Those cases are Carroll Airport Commission versus Lauren and Pan Danner. And the second case is State of Iowa versus Travis Raymond Wayne West. We'll now hear the arguments in the Carroll Airport Commission matter. And Mr. Hamilton, you may proceed.
Good afternoon, and may it please the court. Opposing counsel, I am Steve Hamilton. My co-counsel is Molly Hamilton, and we represent the Danners. My opponent is Gina Batting and Mr. Jeffrey Minnick, who represent the city of Carroll and the Arthur New Carroll Airport. Your Honors, this is a case where Mr. Danner and Mrs. Danner farmed in Carroll County. As farmers, they transitioned from animals to entirely grain raising in the Carroll County area. To facilitate their operation, they determined to put in a device known as a grain leg. I don't mean to offend anyone, but I'll explain it briefly that a grain leg is an upward vertical structure. It's 160 feet, give or take, tall from the ground, and it takes grain, raises it up, and channels it into different bins. It is gravity driven so that these tubes basically that put it in the bin must be a certain height. So he built to that height. He went to the building administrator, applied for and got a building permit. The building administrator of Carroll County, who had held that position for 20 years, states that he was not aware that this particular location was within zoning control of the city airport. And it was. We don't dispute that. But he told Lauren that he's fine, he can go forward.
Was there language in the permit regarding a need to comply or check with the airport regulations?
It does not say that by my view. It charts or it checks exempt for agricultural installation. So he builds his grain leg. The airport folks see the grain leg going up and it triggers alarms in their mind. They initiated, and their first step was to initiate an inquiry with the FAA. The FAA looked at it. The FAA dealt with the city's engineer. The FAA ultimately issued what's called a no hazard determination. Now, there are CFR rulings that control and direct how this is done. There's a CFR, I believe it's 7729, says no hazard determinations govern instrument traffic and VFR traffic, which is the whole gamut of aircraft traffic. And the no hazard determination covers arriving, departing, and en route aircraft. So that's the full range of what aircraft do in the air, other than sit in taxis and cost people money who buy them. So they have made a very wide sweeping determination. The FAA made that determination. So the city airport proceeded to file a nuisance abatement action, sought injunctive relief, directing the Danners to take the grain leg down or at least reduce it by 60 feet. The grain leg at about 65 feet would be perfectly legal. At 125 or 126, it's about 60 feet over the permissive airport limitations. We proceeded to trial. We offered the defense of preemption by federal law. Judge Osland ruled against us. We went to the Court of Appeals, likewise ruled against us. So we're here on further review. Our position is preemption applies. Now,
Mr. Hamilton, are you arguing express preemption or implied preemption?
I believe it would be implied preemption. I believe it would be implied preemption. There is no express statement about preemption, although I will direct the court to a statement. I think there's a federal statute, and my opponent was good enough to point it out. The federal statute gives significant power and discretion to the federal government.
Talking about the exclusive sovereignty language.
I speak of the exclusive sovereignty language as well as a statute cited at page 25 of my opponent's brief. And it says, quote, the administrator of the FAA will develop plans and policy for the use of the navigable airspace and assign by regulation or order the use of airspace necessary to ensure the safety of aircraft and efficient use of airspace. Now, that is a broad, sweeping statement.
But isn't there room for both federal and local regulation for air safety? Are they inconsistent?
Is there room? I believe there is room. However, I believe in your decision of State versus Martinez, there was room there for state criminal legislation as well. But as applied, this court said as applied, it would be preempted.
What weight did the trial court give the FAA determination? Any weight?
I don't mean to be facetious, but not enough for me to win.
Yeah. Well, from my reading of the ruling, I don't know. Once he rejected the preemption legal argument, it didn't seem he gave it any evidentiary weight. Should he have?
Yes, I believe he should have.
Are we on de novo review? Was this tried in equity?
I'm going to hear other. I believe yes. If there are two cases, I say Twitty versus Delta Airlines, and another where the federal courts say when you look at preemption, you're de novo. I have respectfully a disagreement with my opposing counsel over that. I know she believes the law. I believe it's de novo.
Well, didn't the trial court strike your jury demand because it viewed this as a trial in equity?
That's what happened, Your Honor.
So on our de novo review, could we reweigh the evidence and give that letter more weight?
You could.
Or send it back down for if the trial court applied the wrong legal standard and by disregarding the FAA determination, have a do-over on the existing record or a new trial?
I believe that's an option.
Why? But wasn't there conflicting evidence by local pilots that said this tower's a danger? They disagreed with the FAA.
Yes, they did. And I might disagree that there should be a stop sign out here on the street, Your Honor, and I might have some level of expertise. But
hypothetically, if we were retrying this or if we were handling this de novo, why should we disregard the testimony of the pilots versus the FAA letter?
Why should you disregard it? I don't think I'd disregard it, but I'd take it all with a grain of salt. I know you have some familiarity with aircraft, Your Honor. You can be, this Green Lake can be 60 feet tall and be perfectly legal. So there's about another 60 feet that are dangerous. If you were in an airplane and that additional 60 feet is a danger to you, I believe the common sense of every person on this bench will say, wait a minute, that ain't the difference between me living and dying. The difference between me living and dying is being at this point in the air with my aircraft probably pointing downward, and that makes the grain leg, at least the top 60 feet, of no significance. I mean, that's common sense.
You point out that this would cost the Danners $450,000 or roughly
more.
Or more to move. Was that evidence controverted?
No. There was cross-examination on it, but there was no witness to say, hey, this is all wrong. I mean, he's got to take it down. It really is worthless at 60 feet, so I suppose the argument could be made, take about 60 feet off. What do you got? A useless 60-foot piece of machinery. So I think Martinez really sheds a lot of light on this, Your Honor. It came late in the game, so to speak, in our litigation, it was recited by this court that immigration, which I say like aviation, invests significant discretion in the executive branch regarding enforcement. Pilot licensing is FAA matters. The state does not do that.
What about the Freeman case, a pollution case, different context? But in Freeman, obviously, we said that nuisance claims could exist, notwithstanding federal environmental regulatory control. It seems to me that the mere fact that there's a federal statute establishing baseline requirements and safety doesn't necessarily exclude local regulation, absent kind of a clear showing of congressional intent sufficient to create implied preemption. What evidence of congressional intent do you have to show that Congress really wanted to preempt any kind of local regulation?
It's what you justices said in Martinez.
Well, Martinez, if I may, immigration law is an interesting animal. Immigration law affects foreign affairs, as Martinez points out, has been traditionally a part of a federal government involvement in a way that, I'm not 100% sure that, and I invite you to convince me that safety does. The environmental statutes involve safety to some extent. I mean, I make an analogy to Freeman, and I want you to persuade me that, if you can, that Freeman doesn't teach us much here. But in Freeman, the notion was, well, you have a pervasive federal regulatory scheme and a permitting scheme and so forth. But the notion of states having private nuisance actions wasn't necessarily inconsistent with it. We came to a different conclusion, I grant you, in Martinez. But it seems to me some preemption cases have found that the pervasive federal authority does not give rise to implied preemption, and Freeman being the case. So help me distinguish your case and make it more like Martinez and less like Freeman.
It would be very difficult to conjure up a system of laws that could allow different states to create or enact specific statements on air safety. The statement by V. Stewart, the FAA delegated administrator, reviewed this matter, specifically found there is no hazard here. That's a very, very narrow and specific finding. And the statement or the finding and claim by the airport just crashes into it head on. If there's some sort of nuanced fact issue where they don't just hit head on, I would agree with you, Justice, but these things just crash head on in this particular case.
How would you respond to the argument that the FAA sets a minimum safety standard, but that the local airport authorities are free to require a more stringent safety?
That statement is present. I would simply say this. There is nothing in this record that says this is a minimum safety. This says it is not a hazard. It is not a hazard.
What's the point in the no hazard letter? It says it warns that this does not relieve the sponsor of compliance responsibilities relating to any law, ordinance, or regulation of any federal, state, or local government body. That sort of disclaimer in the no hazard letter. What's that in there for?
I think I don't suggest to the court that is just totally useless language. I think that is there. I think it does point out you do need to comply with those rules. But I think, again, I'm going back to Martinez because this case is like Martinez. These things are crashing head on here. I think the statement says, yeah, you have to comply with land use rules and regulations. We're not taking off the hook on all that stuff. But again, there is a direct conflict here, which I think removes it from simply saying, okay, we can have some nuanced legal application by a local commission. And Your Honor, if I might, go ahead. I do want to say, I don't think you can necessarily say that we end up with a less safe situation. We have a situation where I think Mr. Seaman pointed out the circle to land minimums were raised. And that really makes it safer, because what that tells you is before you could descend to 500 feet and not see the ground and be legal. And now they're telling you, no, don't go below 600. So you can make the argument that this is safer. So,
you know, in Martinez, there is no federal determination that regarding this defendant, and here you have this specific factual finding, and that's very persuasive. But do you have any case applying? Do you have any case from anywhere in the country that says this no hazard letter trumps anything that any conflicting finding by the local airport?
The finding is pursuant to no. The answer is no, Your Honor. I could not find a case that specifically says that. Okay. We agree. Thank you for your time. I'll listen to my opposing counsel very carefully. Thank you, Your Honors.
Mr. Hamilton, thank you as well. Ms. Bading.
May it please the court, counsel. My name is Gina Bading, and I represent the Carroll Airport Commission, which has been charged with the operation of the Arthur N. New Airport. I'd like to jump right into the Danner's main argument on appeal, which is reliance on your case of State versus Martinez. I believe that case does not determine the outcome here for several different reasons. First among them being the fact that it concerned the federal immigration statutes, which are a wholly different animal from what we are dealing with here, the Federal Aviation Act. This court determined in Martinez that state mirror image of federal immigration law had been soundly rejected in a prior United States Supreme Court case of Arizona versus United States. This is not a statement that means any state mirror image law of a federal law is preempted. Instead, this court has previously found that independent state law causes of action can parallel federal requirements, that those are permissible. That was the holding of Huck versus Wyeth, which discussed preemption in the context of FDA labeling requirements and state tort claims. Also, the holding in Freeman versus Grain Processing Corp., which
doesn't Martinez sort of illustrate or point out that you need to look at how the law is actually applied in the specific circumstance? You know, in Martinez, it was applied in the context of people applying for a job and then being paid for that job. And in this case, from a practical standpoint, we look at how the law was actually applied here. And so you have the federal law applied to say, in a way that says that there's no hazard here. Everything's okay as long as there's a light that points it out. And then a state law is applied in a way that says, no, that same structure with a light on it is a hazard. So from a practical standpoint, as applied, aren't they in direct conflict?
I don't believe so, Your Honor. First, one of the key elements of Martinez, as I read it, was the fact that the federal immigration statutes had a pervasive scheme of enforcement of those statutes. Discretion among the federal officials, whether to apply those civil or criminal penalties, specifics about what sort of penalties those would be. Here, we're dealing with a no hazard letter, not an order, not a regulation, because the federal regulation here says that the grain leg exceeds the obstruction.
As you know, Ms. Bading, I dissented in Martinez, and the U.S. Supreme Court has a petition for cert in a Kansas case in front of it, so we may find out if they grant cert whether the U.S. Supreme Court agrees with this court or maybe agrees with my dissent or with neither of us. But until then, it's the law, and it strikes me that Martinez, in a way, there's a stronger case for preemption here than in Martinez. In Martinez, you didn't have a situation where the federal government had said what Martinez did is okay, whereas here you have a situation where the federal government said grain leg is okay, it isn't an air hazard. FAA, I think most of us kind of layperson view that the FAA has primary responsibility for air safety in this country. That was their view. And now we have the Carroll Airport saying from an air safety standpoint it isn't okay. Why isn't that preemption under the logic of Martinez?
Well, and it's not just an air safety consideration, Your Honor. The applicable statutes, the applicable state statutes and ordinances also reference the impact that a structure like this can have on the continued viability of the airport. So here we have the Carroll Airport is a regional airport hub in western Iowa. Although the FAA raised the minimum descent levels, that could impact the airport's ability for expansion to continue to attract larger and more aircraft. And so this is, I view it as an issue particularly within the province of the local and state authorities, because those authorities know how the airport operates and how they want their land use around the airport to happen. So
But
it's
you're
a
able
land.
to expand, though, because you could use the power of eminent domain if you need to take those structures. When they did the Des Moines airport, they cleared the whole clear zones and condemned that property. I mean, you're not expanding tomorrow, so you still have the ability to expand. You just might have to use some eminent domain to take care of the clear zones, but right now you're still operational, and the FAA says you're safe.
I suppose that's true, Your Honor, but I just find it difficult to believe that we would want to handcuff a state and local authority's ability to enforce its own zoning regulations. All of the federal court cases and state court cases that I have looked at have recognized that the Federal Aviation Act, even in cases where they have said it preempts the entire field of air safety, does not affect and does not preempt local land use regulations. And that's what we're dealing with here, zoning regulations.
Counsel, I looked at a lot of those cases too, but I couldn't find one where there was a specific no hazard determination in conflict with a local airport saying this is a hazard. Can you cite such a case?
I can, Your Honor. Let me just get to it here. One case was Davidson County Broadcasting versus Rowan County Board of Commissioners. That's 649 Southeast 2nd, 904. It's a North Carolina Court of Appeals case. In that case, the court was considering the building of a radio broadcasting tower. A no-hazard letter was issued in that case. The zoning board said, even though that no-hazard letter was issued, we still don't believe the radio broadcast tower should be built. And the North Carolina Court of Appeals upheld that determination. The same result was reached in Aeronautics Commission of Indiana versus State XREL MS Broadcasting. Very similar fact pattern, again with a radio broadcast tower, a no-hazard letter, and a finding by the local zoning authority that no-hazard letter should not have preemptive effect. A great deal of the reasoning of those two cases is the fact that a no-hazard letter is simply advisory only. The FAA, as recognized in both of those cases and some other federal court cases, does not have any enforcement mechanisms available to it to enforce a no-hazard or hazard determination.
Were the local ordinances in those cases dealing with hazards or nuisances like they are in this case?
I don't want to say yes or no, Your Honor, because I can't recollect whether the ordinances were specifically quoted in either of those cases. In Davidson County, though, they did have evidence from the FAA as part of the record that specifically stated Rowan County is obligated through your federal grant agreements to protect the terminal airspace of the Rowan County Airport. This is control that must be exercised at the local or state level, as the federal government does not have the power to protect that airspace for you. There's the same requirement in the federal grants that the Carroll Airport has, and you'll see that starting at page 116 of the appendix, where the Carroll Airport is charged with protecting that airspace within the runway. And this grain leg is right within the landing portion of the runway.
Is there a middle ground? Hypothetically, if we ruled that this letter does not have preemption as a matter of law to override local regulation, but it's still entitled to evidentiary weight, what weight did the trial court give this no hazard determination by the FAA?
I don't know that that is apparent from the district court ruling. I believe the judge simply found that preemption did not apply, so the airport commission had the ability to abate the nuisance. There are other federal and state court cases that have considered the no hazard letters as part of its determination. And, I think that you could follow those cases. There's a Third Circuit court case by the name of Sicklee, if I'm pronouncing it correctly, Sikkkelee, that I think is very instructive on this issue, although it doesn't deal with no hazard determination. It deals with the issuance of type certificates by the FAA, certifying that a particular new design for an airplane or new airplane part is safe. The Third Circuit in Sicklee said, even though we've got this scheme where the FAA reviews the part, reviews the airplane, and says, yep, it's safe, it's good to go, a state law cause of action can still exist for products liability. The situation in Sicklee was
that seems a little far afield. Hypothetically, if we decide that this letter should have been given some weight, on our de novo review, should we sort of rebalance the equities, or should we remand it for the trial court to do that?
If you're going to exercise that de novo review, I would remand it for the district court to determine. Balanced against that fact is also the testimony from 4 experienced pilots who use the airport, some of them on a daily basis. All of them testified about their view of the hazard this grain leg prevented. It's not a question of, I believe one of them said, it's not a question of when an accident will happen, or not a question of if an accident will happen, but when. And
in view of that testimony, which I agree is powerful, but why did the airport wait roughly 2 years to file the action to compel the removal of the structure?
I don't know that those facts are in the record, Your Honor, but I believe that they were trying to work with the Danners to arrive at some other solution, one of which would have been modification of the grain leg, and that is in the record, although they testified.
But doesn't that render it operates by gravity, and if you lower it by 60 feet, the testimony, as I recall it, you'd have to have all this mechanical conveyor equipment it's not. That would cost several $100,000.
I don't know that the cost of that was in the record. It may have been, Your Honor, but it was an option they explored before the grain leg was constructed, and it was not as attractive to them because of it wasn't as efficient and would have slowed the delivery of grain. But it's still an option.
Was it the airport that sought the FAA determination?
I believe so, Your Honor.
Why did the airport seek that if it wasn't going to abide by the result of that investigation?
I don't know the answer to that, Your Honor. I believe that they wanted to follow through with a process that should have been followed in the first place. And before
Did you have a right to appeal the no hazard determination with the federal courts or within the agency?
I believe that a hazard determination provides for a discretionary review within the federal regulations. Yes, yeah. There is a regulation that provides for a discretionary review of an aeronautical determination by the FAA. However, it provides that you may not file a petition for discretionary review for a determination of no hazard that's issued for a temporary structure, marking, and lighting recommendation.
This is a permanent structure, though, right?
Correct.
Do you know why the airport chose not to pursue an appeal of the no hazard determination?
I don't know, Your Honor, but I believe it's because they felt they had the authority and the obligation to enforce their zoning regulations. One final point that I wanted to make, Your Honor, you asked about whether there is any language in the permit regarding the need to comply with other applicable ordinances. That can be found at page 23 of the appendix, and it does state in bold that all farm buildings or structures are subject to airport zoning ordinances. So the Danners were on notice when they applied for this permit, even though the zoning administrator marked exempt agricultural, that they needed to comply with these other ordinances.
Is a reasonable reading of that document as a whole that the check mark exempt would eliminate a need for compliance with other zoning?
I don't believe so, Your Honor, because it specifically says request for agricultural exemption, and then right underneath that contains the bold language. I see that my time is coming to a close. Did you have a question, Justice Apple? Okay, thank you.
Ms. Bading, thank you as well. Mr. Hamilton, you may present your rebuttal argument.
A few points. I want to second and emphasize that, again, the review by the FAA was sought by the airport. The airport, apparently to their surprise, received an adverse ruling. They could have appealed that. They chose not to. Secondly, I would suggest that as a land use matter, if they had simply proceeded on that basis and said, hey, land use-wise or through the Board of Adjustment, you violated a restriction, it may have been a different matter. But they chose. Their petition for abatement says this is a hazard and a danger, and the trial court reviewed this as a hazard and a danger. And that's why we end up here the way we are. And that's why I say it, because of the unique fact situation and the case was presented, that's where there's a crashing of the two concepts. There's the no hazard by the FAA, and there's the alternate opinion by the airport.
Looking at the FAA determination, it does have some strong language, but one question I had, is this sort of an illustration of that American principle, it's better to get forgiveness than permission? I mean, by the time the FAA looked at it, this thing was basically built, wasn't it? Weren't they kind of dealing with
It was, Your Honor.
Weren't they kind of dealing with a fait accompli when they said, well, here's what we want done with it. You don't have to take it down. I mean, should we give some weight to that circumstance?
You certainly can, but to suggest the FAA has no power to enforce its ruling, in my opinion, is not correct. There is a federal statute that gives the FAA and the FAA acting through the NTSB the power to enforce the rulings they make. It's 49 U.S. Code 46106 that allows the Secretary of Transportation or FAA administrator to bring a civil action against a person in a district court to enforce rulings. So, again, Our position is, had this been pursued as a land use matter, we might be here with a different result. But the city and the airport chose to make this a hazard determination. I suspect they felt they had a stronger case. They did it that way. It was an error because the matter is preempted. Again, you folks said in State versus Martinez that the use of separate sanctions, the federal law in Martinez would have a different outcome than the state law. Again, that's the same thing here. We have a determination of no hazard by the federal government, and the state chose to run right, the city chose to run right head on against it.
If we don't go that far with finding preemption as a matter of law, but we think the letter is entitled to evidentiary weight, and there needs to be a do-over, is it your position that we should do it on de novo review or remand it for the trial court on the existing record?
Now I'm just drawing from my experience, whatever it's worth on de novo means you justices can make that factual determination.
Right.
Thank you.
Let me ask one
Yes.
last question. How would we or any judge balance the possibility of a collision with that tower, a fatal collision, and that possibility, however remote? How do we balance the equities of that versus the enormous cost to the Danners of moving this?
I would ask you to balance it with the Danners with the I know there's a difference of opinion. The remote chance that an airplane would strike that tower. Again, 60 is legal, another 60 is not. I kind of present it this way, Your Honor. If you're flying straight and level 120 feet off the ground, that airport's you're not going to make that airport anyway. I know you have some flying experience, so I'm going with that. Or the other alternative, either you're in straight and level flight or you have an unusual attitude. Well, you're not going to have an upward attitude at that level. You're going to have a downward trajectory. So the presence of the 60 feet of the grain elevator is not outcome determinative. Thank you for your time.
Mr. Hamilton, thank you as well. And Ms. Batting, thank you again. The case of Carroll Airport Commission versus Lauren Danner is now then submitted. We'll next hear the arguments in State versus West.